Hello, everyone. Thank you for joining us this afternoon or this early afternoon. We will begin in about 1 minute, so please bear with us and enjoy.
Good morning, ladies and gentlemen. I hope you are keeping well. Welcome to our third webinar of the Spring 21 series of webinars. By the way, if you would be interested in receiving the recording and/or the slides of the previous sessions, don't hesitate to drop us an email. Today, we will address international employment in general and after COVID-19 in particular. The panel today challenges and international mobility go together, and the challenges are multiple in respect of international mobility. COVID-19 is even bringing an extra layer of complexity to this particular structure. International travel restrictions and quarantine requirements had an obvious and immediate impact on the global mobility, undoubtedly, for those hoping to relocate and those already relocated abroad. Clearly, companies were faced addressing situations of immediate repatriation or eventually extended stay. Tax formalities having to be complied with, social security, certificate of coverage having to be extended, etc. And as such, what came out as a result of this was that companies tended to assess and to evaluate that they didn't have the formal policies and contractual clauses in place to address the crisis situation such as COVID-19. Now, undoubtedly, and going forward, organizations agree that the pandemic will have a broader impact on the form and the use of international assignments. Clearly, short-term assignments will and have been drastically reduced, with a majority of organizations turning to a virtual means of communication together eventually with a business trip, which saw the emerging of a new international mobility scenario, the blended assignments, where virtual working, teleworking, home working is combined with a business trip. And even the authorities address this situation. For instance, in the TCA concluded between the UK and the EU, well, the business trip definition is broadened. Not only from a time perspective, it's now possible to have a business trip in that relationship for 90 days in a 6-month period, but also the scope, the material scope has been enlarged. Activities which previously were not to be considered to be executed in the frame of a business trip now are possibly to be exercised in the frame of a business trip. As such, in the relationship between the EU and the UK, At least the Belgian regional authorities have accepted this broadened definition of business trip. Now, whatever the business driver is, there will always be challenges and also a solution. And one of the first solutions is certainly to have a tailored and to have a format in place, a contract, policies in place, provided with the needed and the appropriate legislation being applicable. And that's what we are going to discuss in the first part of this session. Second part will be dedicated to drafting the contract, and the third part will be dedicated to a workshop approach of the latest trend of blended assignments and the challenges that will bring to companies. So David, the floor is yours.
Thank you, Stefan, and hello, everyone. So today we will be discussing about the determination of the applicable law, which is, of course, a question that employers face a lot in an international context, where elements of the employment relationship are located in multiple countries. This can be the case for a lot of elements of the contract, like the nationality of the parties, the registered office of the employer, the residence of the employee, or the place of the conclusion of the performance of the employment contract itself. Stefan, I think I just lost the control over the slides. If you can maybe just...
You should... Okay, perfect. Yes, now it should be okay.
Let's have it a try. So... Okay, we are back. Sorry for this inconvenience. So we will use to answer this question the Rome I regulation. This is applicable as from 17 December 2009. Before that, other international conventions were applicable. This regulation aims to coordinate the rules applicable to the determination of applicable law in contracts, and especially here the employment contracts. But it's good to bear in mind that there remains differences from a country to another, so there is no 100% harmonization. The big principle of this regulation is to permit the choice of law to the parties, but as the employee is considered as a weak party who doesn't have the same negotiating power as the employer, we are going to limit the choice of law freedom in order to protect the employee and avoid social dumping. Also, the law designated by Rome I can be a foreign law outside European Union, which is called and known as the universality principle. At the end, I will also talk about the overriding mandatory rules that could apply to your worker as its first day in another country. So let me give you now the big picture of the rules before digging into more detail. The first question you should ask yourself to determine the applicable law is, have the parties made a choice of law? If the answer is no, then the law of the country of habitual performance of the contract will apply. This is the first and most important rule out there. Failing, we will use the country where the employee has been hired, second rule. And third rule, if the contract has is more closely connected to another country than the two first, then we will apply the law of that country. This is a very exceptional rule that we will come back to later. If the parties have, however, made a choice of law, then this law will apply, but the protection of the mandatory rules of the applicable law in the absence of choice is, however, guaranteed. We'll see what it means just after. Let's start with the first rule in case of no choice, which is habitual performance. What does that mean? Well, this is just a common sense rule, actually. The workplaces of an employee can vary from a country to another, and it's just a common sense to say that the law should stay proximate with the employment relationship and avoid social dumping. Habitual performance country means the country where or from where the employee habitually performs its contract, at the time where a question or litigation arises between the parties. There is no more specific definition in Rome 1 than what I just displayed, so the judges have a broad interpretation power and can take count many different factors to determine what is the applicable law, what is the habitual performance country. Some countries or judges take into account the time spent in each country if you are working in multiple countries, or analyze the function, see if there is a center of administration or an office where the employee is or comes back after its travel, etc. It is of particular importance to see this next principle applicable to habitual performance country, which is the following. If the employee is habitually performing in country A, but is sent to country B temporary for a mission, or he is transferred temporarily to another country, well, the home country, country A, will remain the habitual employment country and its law will keep on governing the contract. This is particularly important for employers who want to transfer an employee from a country to another in the same group. Let's have two examples here. If you transfer your employee to another country permanently, the receiving country can become and be considered as the new habitual performance country. You will then have to adapt your contract with the new law. However, if it's only temporary, depending on the length, on the context, then the initial country, the home country, can still be considered as habitual performance country. So if you're sending an employee to a country B and, for example, dismiss the employee 2 weeks later, the legislation of country A, home country, could still apply or not. Why or not? As said, there is no 100% harmonization in this field, and national law and judges can still have different interpretation of what is temporary, what is permanent, and which law should be applicable. Let's now see the second rule, failing the country where the employee is hired. This rule only applies in a case of simultaneous employment with one employer in multiple countries and where it is completely impossible to identify one main country of habitual performance. For example, this can be a case for an engineer hired in Belgium and who travels across Europe permanently. There is no habitual performance country, so we will apply the law of Belgium, which is the law of the hiring entity. Note that if you have two employers, you will not be able to apply this rule because you will end up with two rules of two employers in two different countries, and you will have to go back to see which one of those two is habitual. Or you could apply the third and last rule, which is the close links rule, which is located just here. So bear in mind that this is a very, very special rule that is rarely applied in practice, and we will see why. This rule says that if it is possible to determine the applicable law by habitual performance or the hiring place country, so if such countries exist, the law of this country can still be excluded by another country with which the employment relationship has closer connections. It's not a subsidiary step. This means that even if you have an habitual performance country, you have to verify if there is or not another country with more close connections, and the circumstances and facts will then matter here. I said it's very rare in practice. Small example here for the famous or infamous Schlecker case, where the employee was performing for 11 years in the Netherlands, but the employment relationship has multiple ties with Germany. You have the employer registered there, the residence of the employee, the pension plan who was a German one, and some reimbursement of costs, etc. So the judge finally decided that the habitual performance country exists. It's Netherlands, so Dutch law should apply, but the contract is so close with Germany that we should exclude a Dutch law and apply German one. Of course, this is again very exceptional. Now, let's talk about what happens if you have a choice of law. A choice of law should be certain, first of all, and then it's very highly recommended to have it in written, of course. Parties can choose to submit their contract to one law or choose another law for some clauses. And once the parties have chosen the law, this will be applicable, but the Rome 1 regulation provides for a very important limitation in order to protect the employee. It says that the mandatory rules that would be applicable in the absence of choice are guarantees. We'll see what this means in a minute. For definition of what mandatory rules means, those are rules that parties cannot deviate from by mutual agreement. They cannot agree in a contract that they will not apply this rule. It will be imposed to them. So let's take back our diagram to make it as clear as possible. Parties have made a choice. This choice will apply, but we will look at these three rules that we've seen before and see what is the designated law by these rules. And then we'll see if there are mandatory rules in that designated law in the absence of choice, theoretically, of course, and compare it with the law chosen by the parties. Simple example, you have a contract with Armenian law designated 10% in Armenia and 90% of performance in Belgium. The Armenian law will apply, but the judge will look at the country applicable in the absence of choice, which will be Belgium here because it's 90% performance in Belgium. We'll look at the mandatory rules in Belgium, like minimum wage, and we will apply these rules compared to the one in Armenia to the contract. Finally, we'll take into account the overriding mandatory provisions in the application of the contract. These are a special corpus of regulations that are very crucial, even more important than the simple mandatory provision. They are so crucial that the judge that is seized of the case can decide to apply its own national overriding mandatory rules irrespective of the law designated by Rome 1 regulation. So all the rules that I just exposed before can designate, let's say, Italian law, but if the Belgian judges has to face litigation, it can still apply the Belgian overriding mandatory rules. To know what are these rules, we can have a link here with the legislation regarding the posting of workers, like Directive 9671. And these rules will apply as the first day of the employer on the territory. This relates to minimum wage, period of rest, minimum annual leave, safety at work, equality, etc. Here are the 5 bite-sized takeaways that I wanted to give you this morning. There is diversity of national labor law applicable in the EU. We should keep that in mind. In case of mobility abroad, there will always be conflicts of laws, and Rome 1 only coordinates but does not harmonize all these laws. Also, the freedom of choice is a principle, but it's limited, so we should check what would be the applicable law if there was no choice and compare the mandatory rules of that law with the one chosen by the parties, and if they're more protective, they will prevail. So the last and best practice advice for employees is to roughly prepare the departure and transfer of an employee abroad, and it's best to do it in advance. Thank you, and I give back the floor to Stefan.
Thank you, David. After having determined the legislation applicable to different structures of contracts, let's look into detail now how to draft such a contract. And drafting such a contract will undoubtedly have a link with the scenario of international mobility that is going to be applied. I have listed here a number of scenarios which might be indeed and which are very common, like the transfer, the secondment, the simultaneous employment. I'm not going to detail the definitions of these scenarios, but they all have particularities whenever drafting a international mobility contract. And even the blended assignment, which Tim is going to comment in a few seconds, will have its own legislation, and the contract will have also to address this particular element. So first of all, determine the structure and the scenario which is going to be applied. So that's step 1 then. We have identified 3 steps. Step 1 is going to determine which legislation is going to be applicable. And that's what David has been explaining, which legislation will be applicable to a scenario of international mobility. And then the second step is to determine the content of the law which will be applicable. The specificities of that law will have to be determined, will have to be assessed. And then a third step will be to adopt and to imply and to put these specific legislation into one contract. So these are the three steps which we identify. Now, in the third step, whenever the law has been determined, whenever the law has been analyzed, you have the third step by which some of the clauses will be generic for different jurisdictions. They are the base of itself of the contract. And then you have specific clauses, the clauses which will address imperative legislation or overriding mandatory rules, as David was explaining. And it's even possible, in fact, whenever confronted with that duality of rules, that there is some dépeçage being done, meaning that the contract or some of the clauses might be subject to one legislation, some other clauses might be subject to another legislation. So this is certainly the general framework on how to draft such a contract for international mobility. Now, we have identified that there are general clauses and there are specific clauses to be addressed. Now, what are we talking about in practice? Well, the general clauses are the parties to the contract, the function description, the place of employment, exclusivity, eventually what is to be considered as confidential information, aspects of electronic signature, and eventually even also the conventional variable pay regulations. It is not an exhaustive list and can certainly be extended on a case-by-case basis. Also, Europe, the written statement directive, obliges employers, whenever there is international mobility, to provide with certain aspects of the contract. That is the duration of the contract, the currency, and also specifically, and that is new, the regulations in respect of communication in case of flexible working time schedules. Now, these are the general clauses, but Europe is not united, as you know, and indeed legislation is very national. Employment legislation is national. And this is a comparative chart of Europe on the basis of the language that the contract should have, or eventually even on a non-compete clause and when it would be applicable. So that means that specific elements, issues have to be addressed with specific legislation of an imperative kind or overriding mandatory regulations. What are they? Well, David already outlined a few of them, but also the probation period, for instance, will be of an imperative kind, if it still exists, not in Belgium, but in other jurisdictions. In Belgium, also termination of employment, and in most countries, this will be of mandatory imperative legislation. Annual holidays, the number of holidays, but also the holiday pay, for instance. In Belgium, it's 92% of a salary, 96% in Holland. Minimum salary and protection of the remuneration. In France, it's not allowed to index your remuneration, but in Belgium, it's obliged by collective bargaining agreement. And also non-compete clauses, working time clauses are indeed to be addressed based on the specific legislation, imperative legislation, determined based on the legislation that is applicable on that specific contract. So to say and to summarize, the habitual employment, the country of habitual employment, or the contract where the country where the employer is based in case of a simultaneous employment with one employer, to name only those two examples. Other elements to be addressed on a case-by-case basis, so which are not generic, which are not part of the generic elements of the contract, is the payroll structure. You can imagine that if you pay the salary in 13.92 times in Belgium and you pay it 12 times in the UK, and if you assign someone from the UK to Belgium and you still pay that person 12 times, well, you will end up facing an issue in respect of holiday pay and of 13 months, the 1.92 extra payment to be made in Belgium. And this is not theoretical. There is quite some abundant case law which addresses this more in the situations of temporary assignments or secondments. the language of the contract, the protection legislation of trade secrets, although it's a directive, and we gave a seminar on this topic a year ago. Although it's a directive, still the implementation in national legislation differs within Europe. And then you have country-specific regulations, like for instance in France, if you send someone out, you have also to repatriate them. This is also of an imperative kind in France. Daily working and home working, and Tim is going to go into detail later, is also specifically regulated and of an imperative kind because it is health and security. It's based on working time, etc. So all these elements come together and is of an imperative kind. Dépesage, I already explained. The fact is that you can indeed say that the generic elements are subject to one legislation, the legislation of the home country, for instance, but specific clauses like the payroll, like the payment of the remuneration, might then be subject, for instance, to the host country legislation. And that is the idea that we also developed when we drafted a contract for middle management in different jurisdictions, as to allow us HR central function to be able to produce an as much as possible uniform contract, yet adapted to each individual situation. So indeed, we have created a contract for different jurisdictions on your screen, where you have on the one hand the general clauses which are common to all jurisdictions, and we have also taken stock of the imperative legislation of each of those jurisdictions to address and to incorporate them into the employment contract. And it can even be customized based on situation by situation, or eventually even on the basis of the culture of the company. So you will find indeed the contract, which is quite easy to complete on the basis of a questionnaire. The questionnaire will then link it and will produce a contract. And that contract can even be stored and managed, I would say, from one central place for different countries. It will allow indeed a central HR function at least to understand and to have a harmonization of the general clauses in the contract. And on the other hand, specifically also the contract being addressing the clauses which are specific to each jurisdiction. So without any delay, I give the floor to Tim. Tim, who is going to talk about the challenges that companies face whenever addressing the new emerging trend in international mobility, being the blended assignment. Tim, the floor is yours.
Thank you, Stefan. In this final part for today, we will indeed specifically address telework and the cross-border aspects that can come into play in different telework scenarios. As Stefan indicated, companies are considering a new scenario for international mobility, a so-called blended assignment. Blended working refers to blending on-site and off-site working, which is possible through use of course, the modern information and communication technologies that are now at our disposal. The trend towards blended assignments combines this virtual working from home as a home or teleworker with regular business trips. With Brexit, Stefan indicated, blended assignments might also prove a welcome element for companies facing immigration formalities for their employees as a result of the Brexit. In principle, of course, business trips, which do not include actual work but attend meetings, will not require the person to obtain formal immigration documents, and a normal passport will suffice. A business trip can then be combined with teleworking in the state of residence of the employee. This is the case for Belgium, but it's of course always important to check ahead for local legislation on business trips in each state. As indicated by David and Stefan in their parts, first an important point of attention in any cross-border employment situation is determining the applicable employment law. This is of course a determining element when drawing up the employment contract, and it's also crucial in the context of any cross-border telework. In most European jurisdictions, telework is specifically regulated. Also, commonly, specific conditions apply for employment agreements for teleworkers. We'll take a look at some different scenarios. First of all, in the case of our blended assignment, we have an employee working from home. in combination with regular international assignments abroad. We'll take as an example the scenario of an employee working at home in Belgium, being regularly sent on short-term assignments to France and Germany. In this type of scenario, we consider that the home state of the employee, Belgium, is the place of habitual employment. In determining the applicable employment law in respect of the Rome I regulation, the first question is then, as indicated by David, what law the employer and employee choose to apply to the employment contract, however, keeping in mind that the mandatory provisions of the normally applicable employment law, habitual employment or closest link, would in any case have to be respected as minimum standards. A logical choice would be to choose the law of the country of habitual employment, because otherwise the employee would be entitled to the best of both worlds, or better, to the best laws of each of the concerned states. In a scenario of cross-border telework, we often notice that this is not the case. For example, if a teleworker in our example here is based in France and our Belgian teleworker is the only one or one of the only employees working in Belgium, it's not uncommon to come across employment contracts where a choice of laws has in fact been made for French employment law for corporate reasons, as the employer is based there. This would lead to a mix of French law applying whilst also having to respect mandatory provisions of Belgian employment law as minimum standards, on which David and Stefan have already commented. Even for fairly comparable legal systems such as France and Belgium, this can create undesired effects as indicated earlier. For our example, we will assume that Belgian law is chosen. This is also the law of the place of habitual employment. For our Belgian employee, this means that the employment laws of the home state, Belgium, would fully apply. Looking at those Belgian laws, as indicated, specific rules for telework in Belgium, which are moreover different depending on the type of telework, will apply. It can be structural telework, occasional telework, homework, or COVID-19 telework. In that regard, it's here very important to make the distinction between homework and telework, also to determine what type of employment contract is needed. Either a contract for teleworkers or a contract for home workers. We will not address the other forms such as occasional telework here, as the scenario of the blended assignment implies by definition regular telework. When we speak of structural telework, we refer to a form of organizing and performing work using information technology where that work could also have been performed at the employer's offices and is performed outside of that office, and this on a regular basis. If regular, even one day a month, for example, can suffice. For telework, use of IT communication means is an essential element. Structural teleworkers, the most common scenarios, fall under a specific set of rules, Collective Bargaining Agreement 85, and are not subject to the rules of home workers, the general rules. However, if an employer has no premises in Belgium at which the employee could perform the work, the employee can still be a home worker. Both structural telework and homework require a formal written agreement which must mention specific elements determined by law. For structural telework, these are listed on the slide here, these elements. They must be included in the individual contract or in an annex. So that's very important when drawing up the contract that you keep this into account. Often overlooked, there are also collective information duties that may apply when implementing telework. Returning to our scenario of the blended assignment, for the work performed abroad in the context of delimited term international assignments, postings, certain rules of national employment law in the host countries need to be respected as minimum standards as well. To that end, the national rules which implemented the EU Posting Directive referenced to by David earlier in the host state will of course play a determining role. For France, this implies that the rules of French law mentioned here on the slide, those overriding mandatory provisions that apply in event of posting, should be respected, for example, on working time, vacation, minimum wage, and health and safety. Now, let's maybe, while we are at it, try to do a poll and to see whether you're all still here. Have you already considered the effects of that teleworking may have in cross-border employment situations? I will give you some seconds to answer. I think I will close the poll and share the results. So we see that actually 60%, almost 60% has already thought about it, which is very, very good. That's a very interesting result. Of course, you are a very specialized group of people with a lot of experience in this matter. For the ones that hadn't considered it yet, I hope to achieve with today's presentation that you will have a better view on these consequences to avoid any possible negative surprises. They can be important. To further illustrate this, I will first address another scenario on how cross-border element can be relevant for telework, namely that where an employee is normally working in one state for the employer, but also works from his home in another state. In that event, again, the same analysis, of course, applies regarding the applicable employment law. We will assume here that it's a choice of laws for the law of the normal work state, France, in this example, and that the employee is performing the telework in Belgium where he is living. In this event, of course, certain provisions of Belgian employment law can also apply to the telework performed in Belgium. Indeed, of course, as Stefan and David illustrated, an employer temporarily employing employees in Belgium is obliged for that work on the Belgian territory to comply with work and salary conditions imposed by criminally sanctioned provisions and by collective labor agreements that have been declared generally binding by royal decree, with an exception to rules on supplementary pensions. Stefan and David already listed some of the elements mentioned on the slide here. For example, of course, minimum wages, public holidays, working time, well-being at work. But it's also relevant to note that this also includes rules on structural telework, because collective bargaining agreement 85 has been declared generally binding. Also, in the context of today's presentation, we cannot pass on the recent rules that were adopted for COVID-19 telework. First of all, as a temporary sanitary measure in the context of the COVID-19 pandemic, the ministerial decree still provides for an obligation to work from home, which applies to all companies and for all staff members in Belgium, unless this working from home is impossible because of the nature of the function or for business continuity reasons. Certain listed essential sectors and businesses are excluded. If teleworking cannot be applied, the employees must be in possession of an appropriate certificate or any other evidence that is issued by the employer that confirms the need for their presence at the workplace. On 26 January this year, after more than 10 months of COVID-19 telework without any specific legal framework existing, collective labor agreement number 149 was concluded precisely to provide this regulatory framework for that specific type of telework, the COVID-19 telework. It is, however, only of a supplemental nature, meaning that existing agreements on teleworking, and on that teleworking at least, existing before the 1st of January 2021, remain fully applicable. According to these supplemental rules, for every COVID-19 teleworker, agreements have to be entered into as well regarding the provision of equipment and technical support and reimbursements of costs, such as in relation to use of own equipment of the employee and for connection costs. Regarding working time, very interestingly, in absence of different agreement, the COVID-19 teleworker must, on the basis of these rules, in principle follow the same work schedules as apply in the office, but parties can agree differently. In that context, the framework of this CBA also devotes attention to hours during which the employee may not be reached, a sort of right of disconnection, which is very interesting and a very interesting evolution in Belgian law. Of course, obligations on well-being at work for teleworkers and employee monitoring with respect of privacy laws and everything are also specifically addressed in these rules. The application of these rules of the COVID-19 framework for telework also require particular attention in a cross-border context, because for employees normally working in Belgium under a normal Belgian employment law contract who are now working at home abroad, these rules would in principle also apply to their employers. However, in such scenario, it may be the case that specific rules from the country in which the telework is actually performed, those rules would also have to be abided by, and taking into account the supplemental nature of the rules in the collective bargaining agreement. In fact, it should be assessed whether those rules are not sufficient and whether they do not provide a sufficient alternative scheme already. As it has been requested to declare this collective bargaining agreement generally binding by royal decree, it could also apply in event of temporary scenarios of working from home in Belgium under foreign law employment contracts. Also in that scenario, the same assessment has to be made regarding applicable rules or policies under foreign law, which could provide for a sufficient pre-existing framework, thus avoiding the application of the rules of the CBA. Moving back to our scenarios of structural cross-border telework, it should be noted that this can also have an impact on applicable social security. As you may know, if an employee works in multiple EU member states simultaneously and performs a substantial part of the work in the state of residence, as will be the case when working from home, of course, the social security laws of that state will apply in respect of the EU regulations. Teleworking in the home state is substantial, where it takes up at least 25% of the employee's normal working time or salary. That means that if an employee works from home for more than 5 days each month, the social security law of the employee's residence state will apply within an EU context, but that will also be the case in an EU-UK context based on the trade and cooperation agreement concluded in the context of Brexit. It's important for employers to be aware that when an employee works abroad from home for more than 25% of the time, the social security law applying to the employee may change, and that is the case if that employee's residence is in a different state than the normal work state or normal work states. However, regarding COVID-19 telework, which is mandatory in many countries and still mandatory today in Belgium, many member states have indicated that they will not take into account periods of telework performed on their territory for reasons of COVID to claim the application of their own social security regime. Belgium has confirmed this neutralization period to apply from 13 March until 30 June, 13 March of course last year and 30 June of this year, and may be subject to extension still. From a tax perspective as well, it is possible that an employee who works from home in a different state, who has the authority to legally bind an employer, could be considered as a permanent establishment of the employer in the employee's residence state, which would of course create a tax liability in that state. So it's a very important element to keep in mind. Also, outside of any permanent establishment risk, teleworking across borders could entail a personal income tax liability. Similarly to Social Security, bilateral agreements were concluded between Belgium and neighboring countries, France, the Netherlands, Luxembourg, I think Germany as well, to exclude the COVID-19 telework situations in the home state for the change of tax effects, in fact. The agreement with Luxembourg, for example, was recently extended, and I believe it also runs until 30 June of this year. It coincides with the Social Security rules. As a final point, as is the case in any cross-border employment situation, employers should also consider whether employees, and especially non-EU citizens, of course, need a work permit to be able to telework in a particular state. Telework, after all, still remains work. So if rules apply, then those of course need to be abided by. I think we can conclude here, and I leave the floor to Stefan for any final remarks.
Thank you, Tim, for this blended assignment approach. Before we go to the questions, I would like you to answer an extra question, if possible. And we have been talking about that European employment agreement and how to draft it, and also the fact that our network drafted that local contract according to, with some generic clauses, and then the specific clauses which addresses the legislation of each country. So would indeed, would you be interested, or would that be of any, I would say, advantage or benefit to your organization having in place such a contract? And I am launching the poll now, so you should see it on your screen to see whether such a standard approach of contract on a European level would be of any, I would say, interest to your organization. So we are closing and sharing the results on the screen. In fact, it's mitigated. So some companies probably yes, some not, and some are doubting. So I think it's certainly interesting to pursue and to look in the more standardization and to what extent it can help organizations. Looking at the time, we are indeed running out of time. I saw one question, and just going forward to that, if I can read it, will the slides be shared to print participants? Yes. There was one question also whether the standard approach of contract drafting is indeed also available for assignment contracts or simultaneous employment contracts. This is not the case. We have been developing that for national, according to national legislation, for an employment on one territory only. And these are the territories I showed on the screen, like France, UK, Belgium, etc. So it's a local contract, middle management contract. I thank you for your attention. Thank you for being with us this morning, this afternoon. And I can only invite you for our next webinar, which is going to take place on the 22nd of April next month, 22nd of April, and which will be dedicated to the whistleblowing and the new directive, and then whistleblowing from a employment law perspective. We will organize this session together with our top team, privacy team, and outsourcing team, so that we cover different aspects of the new whistleblowing directive and the obligations which are coming up by the end of the year for employers in Belgium and in Europe. Thank you very much again for your attention, and see you next time.